providing evaluations and opinions. Some mediators may use evaluative methods to assist self-represented litigants to make wiser settlement choices and to balance power. These methods include providing self-represented litigants with evaluations, opinions, or the range and/or likelihood of possible outcomes. We explore these methods in greater detail in Supplemental Training 1, but these methods are important to mention here because litigants may seek this kind of help from mediators, and, when used with caution, these methods can be an additional tool in balancing power when self-represented litigants are participants. As we mentioned in the previous section on providing information, mediators can also provide opinions and evaluations to help self-represented litigants balance power. The requirements and the ethical constraints that apply to providing information also apply to providing opinions and evaluations. So let's review them. When providing opinions or evaluations, mediators must comport with the principles of impartiality and self-determination. Next, a mediator must have the qualified training and experience to provide those opinions or evaluations. And again, as we said in the providing information section, there's no specific criteria for this level of knowledge, but the idea is that you should know what you're talking about when you provide these opinions because the litigants will often rely heavily upon them. The California rules also provide that when you are mediating, you should act solely as a mediator, even if you have expertise and training or are licensed in other fields like medicine or law or architecture. I gave the example last time that when you're a physician who is also mediating, you should not practice medicine or do so in a way that might violate the rules and ethics of your medical codes. The overarching reason to supply a self-represented litigant with an evaluation or opinion is to provide them with information that they lack. And as we've discussed in several places in this training, lack of information, especially legal information, is often a huge obstacle in the self-represented litigant's path to obtaining a fair result in mediation. One kind of helpful information to provide is how the law or a legal standard applies to the facts of their case, something that, as a self-represented litigant, they typically aren't trained to do. Relatedly, although somewhat distinct, is what will happen if they go to court. What is the range of possible outcomes if the case cannot be settled and is in fact decided by a judge or a jury? The goal in providing evaluation or opinion is to have the self-represented litigant to have a more objective view of the likely outcome in court if the case can't be settled, and thereby make better settlement decisions. And so if they have a sense that their case is stronger, they may hold out for a better settlement in the mediation. But likewise, if they understand that their case is much weaker than they otherwise thought, then they won't walk away from an otherwise fair offer from the other party. Evaluations and opinions can also help the self-represented litigant better understand the strengths and the weaknesses of their claim, where a mediator gives an opinion on a discrete aspect of the case and not a global prediction about the entire case. Thus, when you give an evaluation or opinion, you provide valuable information to the self-represented litigant that helps them to better and more objectively assess the strengths and weaknesses of their case, and thereby it empowers them in a way that is ethical, because part of your job as a mediator is to help parties think more deeply about their case, and it therefore balances power. Providing an evaluation or opinion is a highly invasive technique in mediation. Thus, even when done well, it presents risks for the mediation process. The self-represented litigant may see the mediator's actions as being partial or biased, even if those opinions and evaluations were truly objective. The mediator may lose his or her neutrality. In other words, he or she may feel strongly that one party is right or one party is not, and act upon that in ways that may be overly coercive. Even if a mediator is not being overly coercive, the fact that the mediator is the expert in the room, the self-represented litigant may take this opinion very, very seriously and not proceed in a way that they might have otherwise that could have been equally as helpful or more helpful in their own context. To minimize the chance that the self-represented litigant would see the mediator as being partial, or that the mediator may lose his or her neutrality, or that the self-represented litigant would feel that the mediator was coercing him or her in giving the opinion or evaluation, mediators should use best practices when providing an opinion or evaluation. These best practices are explored more fully in Supplemental Training 1, but here are a few important suggestions. Evaluate late in the process. Mediators should evaluate as late in the process as possible. The mediator should wait until he or she has enough information to make an accurate evaluation. The parties have had an opportunity to exchange information and problem solve. The parties appear at an impasse that only a mediator's opinion, or sometimes called a mediator's proposal, seems likely to overcome. Providing an evaluation too early can further polarize the parties and shortcut a lot of the cooperation and problem solving that is the hallmark of much of what we do in mediation. Ask permission. Ask permission to provide an evaluation or opinion and explain any reasonable likely risks of providing that evaluation or opinion if you think they exist. For example, further polarization of the parties, losing your neutrality in one of the parties' eyes. The most helpful kind of evaluation to provide is one that gives litigants information about the range of possible outcomes if the matter is adjudicated, and the likelihood of success of those outcomes. So you might say something like this. Overall, based on my experience, I think that you have a 50-50 chance of winning if a judge has to decide this issue, and that if you do win, I think the most likely recovery is going to be between $10,000 and $20,000. And it's very unlikely that you'll get more than $20,000 based on the experience that I have in these kinds of cases. What is not as helpful to do is provide an opinion about what the case is worth or what you would do if you were in the self-represented litigant's shoes. This best practice is consistent with the committee comment to Rule 3.857D, which says that a mediator may discuss a party's options, including a range of possible outcomes, in an adjudicative process. Once you have provided the self-represented litigant with evaluation or opinion, then it's up to the self-represented litigant, according to party self-determination, what to do with that evaluation or opinion. You should not encourage them to act in a way that's consistent with your opinion or evaluation, and you certainly should not advise them to take an offer that you suggest. This best practice is consistent, again, with committee comment to Rule 3.857D. This comment states that the mediator may provide an opinion or evaluation, quote, provided that the mediator does not also advise any participant about how to adhere to the law or on what position the participant should take in light of that opinion, close quote. It's only your opinion. Emphasize that it is only your opinion, either before and or after you give your evaluation. Research demonstrates that experts vary widely in the valuation of a case based on the same facts and law. No matter how certain you feel, acknowledge that it is only your opinion. Don't be directive. Be careful not to be directive. How evaluations or opinions are provided is also critical to how they impact party self-determination. Pay particular attention to your tone giving an opinion. Your tone may unwittingly be too forceful, too confident, and so it would be viewed as coercive even if your literal words are not coercive. The Advisory Committee comment to Rule 3.853 of the California Rules specifically gives, quote, providing an opinion or evaluation of a dispute in a coercive manner or over the objection of the party, close quote, as an example of conduct that violates the principles of voluntary participation and self-determination. Let's address a couple of common concerns when mediators provide evaluations and opinions. Mediators who are not lawyers often have concerns about whether they would be considered practicing law if they provide an evaluation or an opinion. Also, mediators who are lawyers often have concerns about whether they would be considered to be representing the self-represented litigant if they provide legal evaluation or opinion. These are all legitimate concerns. providing an evaluation or an opinion of a legal issue comes closer to providing legal advice than providing legal information. As discussed above, providing legal advice is considered part of the practice of law, and mediators should not do it. To avoid these concerns, mediators may choose to stay away from providing evaluations or opinions about legal issues altogether, and instead use other, more facilitative techniques discussed above to balance power, or suggest that the self-represented litigant seek advice from an attorney or other resources that can provide the law. If a mediator does decide to provide evaluation or opinion about a legal issue, the mediator should be very cautious about doing so. Note that the advisory committee comment to the California Rule 3.857D suggests that, quote, a mediator should exercise particular caution when discussing the law with unrepresented parties and should inform such parties that they may seek independent advice from a lawyer, close quote. Now let's look at a vignette in which I serve as mediator and use evaluation best practices. This is a case where Michael is suing his neighbor Amy because Amy's dog got into Michael's yard and tore up a section of his garden with prized heirloom tomato plants. Moreover, Michael tried to shoo the dog away by hitting it with a metal garden stake, injuring the dog. And when the dog was injured, the dog turned on Michael and bit him on the hand. Michael is suing for medical expenses, pain and suffering, and the loss of his heirloom tomatoes. After a couple of hours of mediation, the parties are still $3,000 apart in settlement range, and it appears that an evaluation would be a good technique to use. So, Michael, Amy is come back and is at $3,000, and you're at $6,000, and you told me that you're really not. We've talked a little bit about this, and you're not willing to move anymore. So, I think at this point we've been going for a couple hours, and we probably only have another half hour or so before the court is going to ask us to come in, and you'll have to try this case. And so, to see if we can avoid that, I think it might be helpful for me to give you my opinion about something in this case that might help to make you think differently about it. It's called an evaluation, and it gives me a chance to give you a little bit of a sense of what I think a court might do, and that helps you make better decisions here. And there's some risks to it, I'll say, that I might say something that you don't like, I might say something you like a lot. It might further make it harder to move forward. So those are just some of the risks of it, but I'd like to do it. Is that okay?
Absolutely.
Okay, because I think it will give you some perspective on this problem that may help you to make a better decision.
Okay.
And, because I think we're at a point where we're not going to make much progress. You both have you worked very hard, you've been very flexible, but this is how it goes. Sometimes you just can't get there. And right now, Amy's at $3,000 and you're at $6,000, and just think that you've both pushed as hard as you can push based on what we know so far. So let me say what I think is holding us up a bit. I think for Amy, it's the garden. You've been very flexible on the pain and suffering. You've moved it down quite a bit. The out-of-pocket medical is the out-of-pocket medical. Mm-hmm. I think you've understood that because you did hit the dog, there's some risks there. We talked about this concept of contributory negligence, right? That the court can lower your reward based on the percentage that he or she thinks that you contributed, right, to the bite, right? So that's just a factual question that the judge is going to decide. But I think the thing that really is separating us is the $5,000 for the garden, right? You put a lot of time in it. These are things that you do every year. But Amy sees them as just tomatoes. Maybe pretty nice tomatoes, and so she's not really willing to put all of that on there. My sense is that the judge is not going to give you the full $5,000 for those tomatoes. And there's a couple reasons for that. One is that you got them for free. Even if you had to pay for them, it's not a lot to pay for them. You put a lot of time into it, but even if we put some hourly rate on there, there's quite a lot that is there for the 20 tomato plants that the dog destroyed. And so my sense is you're not going to get all of it. I understand the arguments. The argument is that you put this time in. It's certainly worth more than going to the store and buying a really nice bunch of tomatoes, but it's going to be someplace in between. And so I think that if you had some more movement on that and you showed some flexibility and recognize that I think it's not likely you're going to get the 5 I think it's closer to maybe 1,000. That's just my opinion, right?
Mm-hmm.
I could be wrong on that, but I think that that's what I've seen in terms of these kinds of things before. I've never handled tomatoes before, but there are times when you have items that people value differently, and so that's my best estimate of what the court might do here, which I understand you may not agree with, but that's my sense of it. And so if you can incorporate that into your estimate, it's probably something that we could get a deal on.
Okay.
Okay? So based on what you're saying, Michael, is you want $1,500 for the medical expenses, $1,000 for the pain and suffering, and $1,000 for the destruction of the garden. And that comes to $3,500. Is that right?
Correct.
So I can take that back to Amy. Now,
yes.
Amy's at $3,000, but I feel pretty comfortable that we're going to be able to move this gap. And I appreciate the flexibility, and I think that we can probably get Amy to move in that as well.
Okay.
Make sense?
Yes.
Okay, thank you.
The first best practice I used was to delay giving an evaluation until further into the mediation process. Here, a couple of hours had passed, and it looked like the court was going to call the parties into trial in about a half an hour. And so I felt at this point there was little use in moving forward with the facilitative method and trying a more directive method like evaluation. I also asked permission, and when asking permission, I gave the risks associated with an evaluation in this kind of situation. The evaluation was also very narrow, so I didn't tell the parties what the whole case was worth, and I didn't even say what the judge was likely to do in the whole case, but just on the narrow issue of the garden and the heirloom tomatoes, which seemed to be the place that was really holding up the negotiation. And I made a prediction, and finally, that prediction, I emphasized it was just my opinion, and that the court might do other things. But based on my experience, this was my best guess as to what a court might do, and this seemed to help the process.
Let's summarize what we've learned about providing an evaluation or an opinion. Providing evaluation or opinion is an ethically appropriate technique to balance power by making the self-represented litigant aware of the range of possible outcomes if the case is adjudicated. However, mediators must take special care when providing evaluations and opinions to not undermine their obligations of impartiality and party self-determination. Employ best practices to minimize risks associated with providing evaluation and opinion. Here they are. Ask permission to provide the evaluation or opinion from the participants. Emphasize it's only your opinion. Don't be directive, especially in your tone. Evaluate late in the process, not early in the process. You must be an expert by training or experience in the matters in which you provide an evaluation or opinion. And finally, never give self-represented litigants advice, even if asked.
You will now be directed to a short quiz to assess your understanding of the information just presented.